Hi, my name is Larry Newman. I'm an Ithaca attorney. Our practice focuses on DWI and DWAI drugs charges. Today I want to talk to you about the differences between impairment charges and intoxication charges. And there's 3 impairment charges and there's 3 intoxication charges in New York State. These are things to remember beforehand. Any extent of impairment, either by alcohol or by a drug, you could be found guilty of a DWAI charge. Now, there's 3 types of DWAI charges. There's DWAI just alcohol. Then there's DWAI drugs. Then there's DWAI drugs plus alcohol. Remember, out of those 3 types of impairment charges, the only one that's a violation is impairment by alcohol, but they all have the same burden of proof. To any extent, impairment to any extent, very low level to prove in court. The 3 types of intoxication charges are common law intoxication, and then there's 2 types of what's called per se intoxication based upon a specific amount of alcohol in the body. So first we have DWI common law. That means common law means they don't need a chemical test of breath. They don't need a chemical test of blood. They don't need a level of any alcohol in your body. They believe, based on their opinion of how you walked, how you talked, how you acted, that you are in fact common law incapable of operating a car safely. And intoxication is to a substantial extent, not to any extent, but to a substantial extent, you're intoxicated. So that's the first type of charge, common law. The second one, per se, means 0.08 or higher. That means that your blood alcohol concentration was 0.08 or higher. Then there's the third type of intoxication charge called aggravated intoxication, which is 0.18 or higher. Remember, these are the differences between all the impaired charges and intoxicated charges. Is intoxication must always be proven to a substantial extent, but impairment only needs to be proven to any extent. And that's where the crucial difference lies, because it's real easy, or it's easier to prove impairment in New York State than it is to prove intoxication. Another thing to remember is if the police are charging you with intoxication charge and also charging you with a DWI drugs charge, they can't have both. They can't prosecute both charges. You are either, in New York State, you're either intoxicated by alcohol or you're impaired by a drug or a drug plus alcohol, but you cannot be both simultaneously. Remember that. So the police may charge it, but whether you're going to be found guilty of it at the end legally is not going to happen. If you have a question about a DWAI drugs charge or DWI charge in the upstate region of New York State, we handle the Finger Lakes. Either give us a call, shoot us an email, or fill out the form on our website. Be more than happy to discuss it with you. And thanks for watching this video.